Hello there, welcome. Now, let's talk about something truly American, waiting in line. We do it for everything, the new iPhone, brunch, a slightly less soul-crushing experience at the DMV. But there's one line that has become an Olympic sport in bureaucratic misery, the line for a green card. And look, if you found yourself in this line during the Trump administration, you might have noticed it's moving with the speed and efficiency of a sloth on tranquilizers. It's not just you. The system, which was already a labyrinthine nightmare designed by a sadist with a passion for paperwork, has had a few extra layers of fun, or as I like to call it, policy-driven despair, thrown into the mix. So, you've done everything right. You've filled out forms that ask for your mother's maiden name and your third-grade teacher's opinion of your penmanship. You've paid fees that could fund a small nation's space program. You've submitted a stack of documents thicker than a phone book from a city that still has phone books. And now you wait, and then you wait some more, staring at a case status that hasn't changed since flip phones were cool. It feels personal, doesn't it? Like somewhere a government official is using your file as a coaster for his lukewarm coffee. But here's the thing. While it feels deeply personal, the reasons for these delays are often systemic, political, and frankly, a bit ridiculous. Today, we're not just going to wallow in the shared frustration, though there will be plenty of that. No. We're going to arm ourselves. We're going to dive deep into the swamp, and yes, I know he loves that word, to understand what's causing these delays and, more importantly, what you can actually do about it. We're going to talk about 10 concrete strategies to navigate this mess. So, grab a coffee or something stronger because we're about to untangle this glorious star-spangled knot of red tape. First up, let's talk about the delightful phenomenon of policy-driven suspensions. This is when your application isn't just slow, it's been deliberately put on ice. Think of it as the government pressing a giant pause button, often without sending you the memo. These can stem from executive orders, travel bans, or new internal vetting procedures that are announced with all the clarity of a heavily redacted UFO report. The first step is to figure out if your case has been caught in one of these nets. Are you from a country targeted by a specific proclamation? Does your visa category fall under a new, vaguely worded national security review? This isn't about you forgetting to dot an I. This is about a top-down policy shift that has effectively frozen your file in bureaucratic carbonite. Recognizing this is crucial because your usual follow-up methods won't work. It's like complaining to a cashier that the whole supermarket is closed. You need to elevate your game. This is the point where you absolutely must seek support. Contacting an experienced immigration attorney isn't a luxury, it's a necessity. They can decipher the legalese and tell you if your case is subject to a specific hold. Furthermore, groups like the ACLU or the American Immigration Lawyers Association, AILA, are often tracking these suspensions and sometimes even litigating against them. Joining their mailing lists or checking their websites can give you the vital information that USCIS simply won't. Understanding the why behind your delay is the first step to crafting a strategy that isn't just shouting into the void. Alright, let's move on to another black hole where applications go to disappear time-intensive screening processes. The most famous of these is the FBI name check. This sounds simple enough, right? They check your name. How long could that possibly take? Well, if your name is even remotely common or shares a syllable with someone on a watch list from 1982, you could be in for a very, very long wait. Your file gets sent to the FBI and it sits in a queue until an agent can manually review it. This process is about as transparent as a brick wall, and delays can stretch from months into years with zero explanation. It's a system that can flag John Smith from Ohio because a J. Smith once jaywalked in Pakistan. Then there's the even more mysterious cousin of the name Check CARP, the Controlled Application Review and Resolution Program. This is a secret program, so secret in fact that USCIS denied its existence for years, that flags applications for extra security screening based on a whole host of vague criteria. If you've been flagged under CARP, your case is effectively sent to a parallel, much slower universe where the normal rules of processing don't apply. Again, this is where legal counsel is your best friend. An attorney can help you file inquiries to determine if your case is stuck in one of these security loops, and in some cases can help challenge the basis for the delay. Monitoring your case is key, but knowing what you're monitoring for is the real power move here. Now for something you actually have a significant amount of control over, the application itself. Look, the immigration system is actively looking for reasons to slow you down. Don't hand them one on a silver platter. Submitting a perfect application is your first and best line of defense. This doesn't just mean filling in all the boxes. It means double-checking, triple-checking, and then having someone else check everything. Every name spelled correctly, every date in the right format, every question answered. Did you attach the right fee? Did you sign in all 7 places that require a signature in blue ink on the 3rd Tuesday of the month? It feels ridiculous, but one tiny mistake can send your entire file to the back of the line. And then comes the dreaded RFE, or Request for Evidence. This is USCIS's way of saying, you missed a spot. When you get an RFE, you need to treat it with the urgency of a ticking time bomb. They will give you a deadline and you must meet it. But more than that, your response needs to be as comprehensive as humanly possible. Don't just send the one document they asked for. Send that document along with supporting evidence that proves it's the right document and a cover letter explaining why it's the right document. Over-prepare. Drown them in organized, well-labeled evidence. The goal is to make it impossible for them to come back with another RFE. A weak or incomplete RFE response is a one-way ticket to Delayville. Population U. Let's talk about a feature that feels like it was ripped straight out of a video game premium processing. For a hefty fee, and I mean, currently over $2,500, USCIS promises to process certain types of petitions within 15 calendar days. Now, this isn't available for all applications, most notably, not for most family-based green card applications like Form 1485. It's primarily for employment-based petitions like the I-140 or certain non-immigrant visas. If you are eligible and your employer is willing to foot the bill, this is often the single most effective way to leapfrog the standard molasses-like processing queues. It's the fast pass of the immigration world, and if you have access to it, you should absolutely explore using it. But what if premium processing isn't an option? There's still a slim chance for a speed boost through an expedite request. This isn't something you pay for, it's something you plead for. You can request expedited processing if you meet very specific criteria, such as a severe financial loss to a company or person, a medical emergency, a humanitarian reason, or a compelling US government interest. You can't just say, "I'd really like my green card now, please." You need to provide extensive, compelling evidence to back up your claim, a doctor's letter detailing a critical illness, proof of imminent business collapse, or a letter from a federal agency. It's a high bar to clear, but for those in truly urgent situations, it's a vital tool to have in your back pocket. So you've followed up, you've escalated, you've been patient, and your case is still gathering dust in a government basement. You feel powerless, but you're not. There comes a point where the delay is no longer just slow, it's unreasonable. And when a government agency is being unreasonable, you have the right to take them to court. This is called a writ of mandamus lawsuit. Essentially, you're not suing to get your green card approved. You're suing to force USCIS to simply make a decision, any decision, on your long-pending case. The mere act of filing a lawsuit often magically gets the gears turning, since it's often easier for the government to adjudicate your case than to fight it in court. This is not a DIY project. You absolutely need an attorney to file a mandamus action. It's a serious legal step, but for cases that are stuck well beyond published processing times with no explanation, it can be an incredibly effective last resort. A slightly less aggressive but still useful option is contacting the USCIS Ombudsman. This is an independent office within the Department of Homeland Security that helps resolve case problems. Filing a case assistance request with the Ombudsman can sometimes shake a stuck file loose. Think of it as calling the manager when the regular employee can't help you. It doesn't always work, but it's a formal channel for escalating your problem before you resort to the nuclear option of a lawsuit. The public charge rule. This has been one of the Trump administration's signature changes. and it has sown confusion and fear throughout the immigration system. The idea, in theory, is to ensure that new immigrants can support themselves financially. In practice, it has become a much broader, more subjective wealth and health test. It's no longer just about showing you have a sponsor. Officers now look at a totality of the circumstances, including your age, health, family size, assets, resources, financial status, education, and skills. They want to see a history of financial stability and are looking for any reason to believe you might, at some point in the future, use public benefits. What this means for you is that you need to prepare a fortress of financial documentation. Don't just submit the required affidavit of support, go above and beyond. Provide tax returns for multiple years, letters from employers detailing your salary and job stability, bank statements showing consistent savings, proof of health insurance, and evidence of any assets you own, like property or investments. If you have a high school diploma, include it. If you have a professional certification, include it. You are essentially building a case to prove that you are a fiscally responsible, self-sufficient individual. In this climate, it's better to provide too much financial information than too little. Leave no doubt in their minds. Trying to fight this battle alone can feel incredibly isolating. You're one person against a massive, faceless bureaucracy. But you are not alone. There are thousands, if not hundreds of thousands, of people in the exact same boat. This is where the power of community and advocacy comes in. Connecting with advocacy groups like Boundless, the National Immigration Law Center, or local community-based legal clinics can be a game changer. These organizations are on the front lines, tracking policy changes, identifying delay patterns, and sometimes even organizing class action lawsuits that you could potentially join. They offer a wealth of information and resources that you simply won't find on the USCIS website. These groups often hold Know Your Rights workshops, provide free or low-cost legal consultations, and run campaigns to put public pressure on lawmakers and government agencies. Following them on social media or signing up for their newsletters can keep you informed of the latest policy shifts and give you actionable steps you can take, like participating in a call-in day to your congressional representative. More than that, they provide a community. Sharing stories and strategies with other applicants can be a huge source of moral support and practical advice. Remember, a single voice can be ignored, but a chorus of voices is much harder to dismiss. In the world of immigration bureaucracy, passivity is your enemy. You cannot just submit your application and hope for the best. You have to be persistent. You have to be the squeaky wheel. This starts with regularly using the tools USCIS provides, even if they feel useless. Check your case status online weekly. If your case is outside normal processing times, which you should also check monthly as they change, submit a case inquiry or service request through their online portal. Yes, you will likely get a generic, unhelpful form letter in response, but you do it anyway. Why? Because it creates a paper trail. It establishes a documented history of your attempts to get information. When the online inquiries fail, it's time to escalate. The next step is to schedule an InfoPass appointment to speak with an officer in person, though these are becoming harder to get. The more effective route is often to contact your U.S. congressional representative or senator. Every elected official has staff members dedicated to constituent services, and that includes helping people with issues involving federal agencies like USCIS. A congressional inquiry won't guarantee a result, but an inquiry from a lawmaker's office carries more weight than one from an individual and can often prompt USCIS to at least review your file and provide a status update. Be polite, be persistent, and keep a record of every single call, email, and inquiry. While you're waiting for the big prize, the green card, it is absolutely critical that you don't lose your legal footing in the meantime. The long delays mean that your interim documents like your work permit or your travel document might expire long before your case is decided. Letting these documents lapse can have catastrophic consequences. You could lose your job, be unable to re-enter the United States if you travel, or even fall out of legal status entirely, which could jeopardize your entire green card application. This is an unforced error you cannot afford to make. Therefore, you must be incredibly proactive about renewals. The rule of thumb: is to apply for the renewal of your work permit and travel document as early as USCIS allows, which is typically 180 days before the expiration date. Don't wait until the last minute. Given the current processing times, even applying 6 months in advance might not be enough to avoid a gap in authorization. Keep copies of everything: your current cards, your renewal application receipt notices. These receipts can sometimes provide an automatic extension of your work permit for a certain period. Always have your documentation in order and ready to show an employer or an officer at the border. Your life doesn't stop while you wait, and maintaining your interim status is the key to surviving the delay. Finally, if there's one thing to know about the United States immigration system, especially in recent years, it's that the goalposts are constantly moving. A rule that was true yesterday might be different today. A form that was valid last week might be obsolete this week. New memos, new regulations, and new executive orders can drop at any time, often with little warning. You cannot afford to be complacent. Staying updated on these changes is not just helpful, it's a fundamental part of a successful immigration strategy. You need to be a student of the system you're trying to navigate. This means regularly checking official sources like the USCIS website for policy updates and news alerts. But don't stop there. As we've discussed, following reputable immigration attorneys, advocacy organizations, and news outlets that specialize in immigration is crucial. They can often provide analysis and context that the government's own announcements lack. Being prepared means anticipating potential changes. For example, if you hear rumors of increased scrutiny on a certain type of evidence, start gathering that evidence now, just in case. The more informed you are, the more quickly you can adapt your strategy and your documentation to meet new requirements, ensuring that a sudden policy shift doesn't derail your entire journey. So there you have it. 10 strategies to help you fight back against the soul-crushing inertia of the immigration system. It's a complex, often infuriating process, and let's be honest, none of these are magic bullets. They require diligence, persistence, and often professional help. It's a marathon, not a sprint, and it's being run on a track made of quicksand and broken glass. The emotional toll of this uncertainty is immense, affecting your work, your family, and your ability to plan for the future. It's a heavy burden to carry, and it's important to acknowledge that. But knowledge is power, and being proactive is your best defense. By understanding the potential roadblocks, preparing meticulous applications, leveraging every available tool, and building a support network, you can transform yourself from a passive waiter into an active advocate for your own case. You can take control of the things that are within your control, and that itself is a significant victory. This journey is a testament to your resilience and your commitment to building a life here, and that is something worth fighting for, no matter how long and winding the road may be. Remember that you are not just a case number. You are a person with a story and a future, navigating a system that often forgets that. Keep pushing, keep documenting, and keep advocating. The path is difficult, but it is not impossible. Thank you for watching. Please don't forget to subscribe and like this channel for more informative videos.